Good morning, everyone. Morning. Countryside Rights Away panel, Friday the 10th of October 2025. We'll start with the agenda. Item number 1, apologies. Joe, any apologies?
Thank you, Chair. Yes, I've received apologies from Councillors Val Chapman and Warwick Mackenzie. Thank you.
Okay, thank you, Joe. Any declarations of interest, please, by anyone? That's a no, thank you. Minutes of the meeting held on the 12th of September 2025. I think that was the Vice Chairman. Vice.
I'll sign those.
Sign those over for me, please, thank you.
Thank you very much, Mr. Chairman. I'll sign those as a true record. Is it just at the bottom, Joe?
Yes, please. Thank you
very much. Thank you. Okay. Item number 4, please, on the agenda. The Commons Act 2006, application to register land at Falmouth Avenue in Stafford as a town or village green. If I could pass you over to Claire Gledhill, please. Thank you, Claire.
Thank you, Chair. Good morning, members. So I will start with a recommendation in this matter. So the recommendation here is that the application reference number NVG35 for the registration of land at Falmouth Avenue in Stafford as a town or village green should be rejected for the reasons set out in the Inspector's report dated the 16th of December, and that members of the public should be notified that the reasons for rejection of the application are those contained in the Inspector's report of the 16th of December. So this matter concerns an application by Mr Edward Bailey to register land at Falmouth Avenue under section 15.2 of the Commons Act 2006. The application land is shown at Appendix A in the report. The landowner in this case is Staffordshire County Council, and after initial consultation, the council submitted an objection to the application, citing that signage had been erected on site and it would have been made clear that public rights would not have been accrued over the land. The council, acting in its capacity as Commons Registration Authority, instructed Mr William Webster, a barrister at law, an independent inspector, to advise on the matter on the documentation alone. I'll just explain the legal framework. So section 15.2 of the 2006 Act enables any person to apply to register land as a town or village green in a case where A significant number of inhabitants of the locality or of any neighbourhood within that locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years, and that they continue to do so at the time of the application. In his investigation of the matter, Mr Webster has detailed the legal requirements for registration and analysed the evidence contained within Appendix B thoroughly. He has detailed these points in his report at Appendix C. It's therefore not my intention to read through his report here, but I will summarise as follows. The lawful sports and pastimes requirement, the activities described by the applicant's witnesses is well supported and well documented in this application, and they do amount to qualifying lawful sports and pastimes. In relation to the neighbourhood and the locality requirement, the Bassett ward, where the application land is situated, is a local government ward and does qualify as a locality. The significant number requirement, the applicant has produced evidence from a considerable number of local people who seem to live in the streets close to the application land, as you would expect. In relation to the as of right requirement, there are two potential arguments here pointing to the fact that recreational use was not in this instance as of right. Firstly, that recreational use was forcible in those periods where the application land was licensed for grazing, and secondly, that recreational use was permissive after the erection of signs on the application land. The wording on those signs erected on the application land on the Falmouth Avenue frontage was sufficient to render any use of the land permissive, and that the erection of these, at least two signs, assuming that those had been located in places that would have been clearly visible to reasonable users, and it's highly likely that this is the case, meant that any subsequent use of the application land would have been permissive and prima facie not as of right and therefore not qualifying. The 20-year requirement, the applicant has failed to establish qualifying use through the relevant qualifying period ending in November 2012. Mr Webster does go into detail about this in his report, and it's attached at Appendix C. So therefore, in conclusion, the applicant has failed to establish that the use of the local people was as of right, and it fails to meet the legal requirements for registration. Therefore, it is the recommendation of your officers that the application be rejected.
Okay, thank you, Claire. Any comments?
Thank you and good morning, everybody. I'm County Councillor Anne Edgeler and Borough Councillor for Bassett Ward as well. Oh, sorry, ma'am. Excuse me, I thought I've got some. Sorry. Yeah, I've been the ward councillor now for 26 years, and in that time, that land has been used for public use, for people walking the dogs, in the winter, when it's snowing, the children use it for sledging, and it's just been used for public to be able to use it as facilities for pleasure, really. You know, and all right, this land, my understanding is this land was bought in the 1950s by the County Council to build a new school, which never got built. So I've lived in that area now for 55 years, and in 55 years, that land has been used by the public for pleasure use. And this is why this application came in, to make it legal to be able to do that. And unfortunately, the barrister doesn't agree, and I don't know all the legal implications. I'm no expert on that. But I do believe that, you know, an application was put in years ago, and it is a good few years ago, to build on that land, but it was rejected by Highways, and it was rejected because the road there isn't wide enough to take any more traffic. So it's an ideal situation for people to be able to use it as a leisure facility, you know, and if we could do that, which would be absolutely brilliant, because at the end of the day, there isn't a lot of facilities. I mean, I've got an old gentleman, he's in his 80s, he's put a bench on there so that people can go and sit and enjoy the pleasure of, you know, seeing people walking by. It's a bit of a social activity to them. So it's really important for the elderly as well. They use it an awful lot, especially for walking the dogs. So, you know, it's... I haven't really got anything more to say apart from I'm really sorry, and I'd like to think that we can send it back for reconsideration, but I don't know whether that's a possibility, because as I say, in 55 years it's always been used as leisure facilities, and I cannot understand why it's been rejected. So I'll leave that case, you know, with the committee to discuss it and see what your thoughts are, but it's yeah. Okay. Thank you. Thank you, Chairman, for letting me come and speak.
Thank you, Anne. What do you recommend, Claire? What do you think? Do you want to answer any questions?
So the recommendation is to reject. There is obviously a set criteria as to what's got to be achieved in order to allow an application for a town or village green. And in this instance, the qualifying period doesn't meet the requirement, the 20 years. Because of when the application was made, it will then go back 20 years from that point. And secondly, the knockout blow really is the signage for the permissive use.
Come back on that,
yes,
Chairman, please.
Yeah.
I mean, that signage, actually, it's not very visible, I've got to say. It's not... in fact, we asked for new signage to be put up because fence had been pulled down. I mean, there isn't really a fence there to stop people walking on it, but what bit there was, it was pulled down. I think a bit of vandalism. But, so, you know, the signage it doesn't stop people going on there. It does not. You know, so the county council to say, or the barrister say, that signage is visible. It's not. It is not visible at all. And I've got one gentleman, he's created a little garden on it, you know, and there.
Thank you, Anne. When was the signage put? Can you just refresh my memory, please, Claire?
If you just bear with me.
Yeah, and what does the signage say?
So, so the signage states, Staffordshire County Council express consent is hereby given to the public to use this land for recreational purposes. Rights under the Commons Registration Act 1965 as amended are not hereby created. This permission may be withdrawn by the County Council at any time. So the 2006 Act will have superseded the 1965 Act. So we've obviously put those signs up as a landowner to say rights can't be created over this. There is no objection to the land being used for that purpose, but it's permissive use. It's not qualifying use under the Commons Act 2006.
Mike?
So going through the application, it was made 13 years ago? Was it 2012?
Yes, I believe so, yeah.
Well, you've got another 13 years of qualifying under use, or does that not qualify?
So if the use has been continuing, but there's I mean, like I say, the knockout blow is the fact the signage was erected. So that it doesn't qualify as a town or village green according to the barrister's analysing of the evidence.
And I'm guessing that the reason for applying for village green status is to protect the space. Are you saying that there is another protection in place?
I'm not aware that there's another protection of that piece of land. Like I say, the landowner being the county council, as Councillor Edgeler said, that it was purchased or acquired to build a school on. I don't know the reasons from the landowner's point of view because I'm acting neutral as a Commons Registration Authority. I don't know what their long-term plans are for that land, but they don't currently object to it being used for recreation, but they just don't want to create any rights which would prevent anything happening on it in the future. I can't comment on that because I'm not here for the landowner.
Councillor?
Yeah, as the honourable lady said across the way that there was a fence, but it had been pulled down. So actually there was a fence a long time ago, so really the access was illegal, really, because there was a fence. So if that fence had been pulled down, it had been pulled down by somebody. So that's what I think anyway.
Yeah, go on.
Thank you very much. Yeah, I say a fence. It was just part of the fence. It wasn't the whole stretch of the land that was fenced off. No way. Because there used to be cattle on there. When I first arrived on the scene many years ago, there was cattle on there. There was a big old bath where the cattle used to get the water and that from. But I'm going back 50 odd years. And that's why I say it was only, I think that was to keep the cattle in actually. And it was only part of the land that was fence, not the whole of it. You know, these signs, there isn't visible signs there to stop people going on there. There is not. There's probably one in the middle, and it's, yeah. I just don't understand. For 55 years, it's been used as pleasure and local, you know, for facilities for people to be able to use and enjoy. And now, you know, and they're asking for permission to do it full time. And it's been refused. I just don't understand it at all. So I'm asking, please, if it can be sent back somewhere.
Okay, thank you, Anne. So we're not clear if there's any future developments proposed on the land at all, Claire?
I don't have any information of that. I don't know what the plans are from a landowner point of view.
I mean, if it is approved, then nothing will be able to be developed on it again, will it?
If you go against the recommendation to reject and you want to accept it, it doesn't meet the criteria, so you'd need a reason as to why it would then therefore meet the criteria if you disagree with the recommendation. if it was added as a town or village green, if it did meet the criteria, then it wouldn't be available for development. But obviously, like I say, the recommendation is to reject. Who knows what the long-term plans are for that land? There currently is no objection to it being used as, and there's no question that it's been used for 55 years. It's just that the application, when it was made, and the qualifying time periods of those witness statements don't cover 55 years. They don't cover the 20 years because it was used for grazing at a certain point, and also signage was put up which stops that use then from being qualifying.
Yeah, the previous administration, my understanding is they didn't hold these committees. Is that right?
The Crow panel, yes, they did. We had a Crow panel with the previous administration monthly. Village Greens just don't appear very often. We have a backlog of Village Green applications that we've been working through, which is why they're now coming to panel. We had a few a couple of months ago that I did a few in one go. We're just sort of working through that backlog at the moment, so it's not a regular item on the agenda.
So, as I see it then, is if we go with the recommendation to refuse the application, nothing changes. The villagers carry on using it as they have done. If we go against the recommendation of this learned barrister, he obviously has more knowledge than we do on it. So, but if we put this back to be reconsidered, do you think there's much chance of it being passed through because there's more time than like the extra 13 years?
I think it's unlikely, given the way that the evidence has been reviewed by the barrister. He's very experienced. We're using him on all of our backlog matters at the moment. Actually, we've got 20 odd that he's advised on, and we've brought some of them to panel. Some have been dealt with by delegated decision. The fact of the matter is that the signage prevents the application qualifying. That signage is not there to stop people using the land. It's there to make it clear that they can't obtain rights by using the land. It is a permissive use, not as of right.
Thanks, Claire. What's the reason for the applicant to apply for the status? Yeah.
Because it has been, sorry, Chairman, I apologise, it has been used as a leisure facility for such a long time, and so they felt that, you know, to go for it legally was the right action to take, instead of just letting it plod along and nothing, you know, so it gives them the right really to be able, and it would then enable the Bassett Community Group actually to apply for funding to build something on there, like a BMX track or something for the children or whatever. You know, it's, as I say, it's, and coming back to this signage, there's a lot being made about this signage. I wish you could have a look at it and see where the signage is, because there's one little sign in the middle, and that's because years ago I was complaining about, you know, there was no signage because people were complaining they shouldn't be using it and all this. But so what can I say apart from that it's been used? I mean, can I ask a question then? Okay, you say it's been used 13 years in your submission, and if it was used for another 7 years and nothing happened, would then that qualify then for local green space?
Well, the 20-year period would need to cover prior to the signs being erected. So if the signs are already erected from that point, you can't then make an application beyond that point, because those signs make it clear that the use is permissive. So therefore it would need to be prior to the signs being erected. That 20-year period would need to be prior to that.
Sorry, you keep coming back to this signage. I wish you could go and have a look at it.
Councillor, do you have any evidence of this signage? Have you got pictures or anything you can show us? No. That might have been helpful.
I haven't got them with me. I mean, I'm happy to go away and get that information for you if you wanted to defer this to the next panel, for example, so that you could have a look at fully all the information. And potentially I could speak to the landowner representative from the council if they can provide that up-to-date evidence. I'd have to go back through the file to have a look for the photos. The photos and everything that was on the file has been looked at by the barrister, and that's how he's come up with his report. But I just don't have them in front of me at the moment, so happy to go away and get that information if you wanted that before you made a decision.
Okay, thanks. Anne?
And I may keep coming back in.
No, it's fine.
I mean, there's two public footpaths adjacent to this land. One that runs to the back of Saxon Fields. I don't think there's any signage there. I'll be corrected if I'm wrong, but I don't think there's any signage there to tell people. And there's another footpath that runs at the back of Falmouth Place, Falmouth Close, that is, I had to get it cleared actually not long ago because it was really overgrown. And there's no signage there either. So, as I say, there's a lot to play on the signage, but there's not a lot of signage around, I can assure you.
Councillor Beardmore?
I'm just a little bit confused about when the signage was put up. And has the evidence got to be 20 years previous to the sign to make it legal?
Yes, so the signage will have then made it clear that that is permissive use, so therefore the 20 years would need to be prior to that. I was just looking back through the inspector's report, and it says here there are 2 photographs showing the signs in situ in 2005. So, but then the 20-year would need to be prior to those signs being put in use. So if the evidence has come in, and I have to admit I haven't looked at it recently, so there was a lot of evidence that came in, summarised user evidence forms, etc., to say when people have used it. If any of that use had occurred after 2005, then it would not qualify as qualifying use. So that then reduces the amount of user evidence that we have to then prove that the 20-year use has been achieved, if you like, in terms of the legislation.
So does that mean that if there's evidence between, say, 1985 and 2005 that area has been used, then is that permissible?
Potentially, yes, that would be something that we'd go back to, obviously, the barrister for, but the evidence that was submitted was a qualifying period from the date of the application, 20 years back from that point, I believe. But again, I'm happy to go back. This matter has been investigated by the barrister, not by myself. So therefore, I'm not in the detail as much as he would be. So, like I say, I'm happy to go back and get that further clarified if that's what you require before making a decision.
Yeah, I think that's what we need to do. Have you got another question?
Is there any evidence of any ancient pathways across the land or any walkways across the land that's been registered, please?
Not that I'm aware of. I haven't investigated that because that was not within the remit of the Village Green application. It was just purely whether it met that criteria, so I haven't looked into whether there's any ancient pathways across there.
Okay, thank you.
I think what we need to do is we need to go and try and recommend to the panel that we defer this till we've had a look ourselves at the actual bit more evidence and even possibly go for a site visit.
I was going to suggest that to you, but I didn't know whether that was permissible from this committee.
You can ask anything.
Pardon?
You can ask anything.
Well, can I ask then that you do a site visit and you have a look at the situation, and that because there is that footpath, and that might be a really old footpath because it's been there an awful long time, you know, and so yes, I'll leave that with you, Chairman. Thank you, and the committee, and thank you for listening to my comments.
Thank you very much. So,
Any more comments?
any more comments? Do you want, shall we recommend to possibly have a site visit, just to have a look at some more evidence ourselves with the panel? Yeah, and defer it till another meeting. Is that fine? Is that okay?
That's fine.
All in favour of doing that? Yeah.
Thank you very much,
that's
Chairman.
approved
Thank you,
then.
committee, for listening to me.
Thank you. Okay. Move on to item number 5. This is the Wildlife and Countryside Act 1981, an application for the upgrade of the public footpath 10. Onecote, I think they pronounce that way. Is that correct, Sue? Onecote, yeah. To Byway, open to all traffic. And that's Laura, please. Thank you, Laura.
Thank you, Chair, members. So this is an application for the upgrade of public footpath 10 Onecote to a byway open to all traffic. The application is supported by historical evidence. The application route can be seen marked A to B on the plan attached at Appendix B. We have received no comments from the local member. Turning to the recommendation, after a thorough review of the evidence submitted by the applicant and discovered by the County Council, it is the opinion of officers that the legal test has not been met. The evidence is insufficient on the balance of probabilities to conclude that a byway open to all traffic subsists along the claim route. The documentation considered and analysed as part of the investigation can be found at Appendix C, which consists of the Bradnop Enclosure Award 1769, a handover map of 1929, National Parks and Access to the Countryside Act 1949, highway data of 1987, a report of Staffordshire Moorlands Advisory Committee of 1990, some county surveyor letters, ordnance survey maps and some commercial maps of Yates, Greenwoods and Bartholomew. Scrutiny of the evidence has taken place and a detailed account of findings are contained within the report, and I'll briefly outline these key points that support that recommendation. The earliest documentary evidence to the application route is found in the Bradnop Enclosure Award of 1769. This award describes several public and private roads, with the application route clearly listed among the private roads. The accompanying plan identifies the route as number 42, connecting with 2 other routes. Within the written provisions of the award, the route is described as a private horse and carriage and drift road. This terminology indicates intended use for horse-drawn vehicles and is a drift road, commonly understood to be a route over which cattle may be driven. While the award references several landowners and local inhabitants, this does not confer or imply public rights. Crucially, the award does not specify a width for the application route, whereas public roads are typically described with defined widths and distinct terminology. This disparity strongly suggests that the route was not intended to accommodate public use. The 1929 handover map does not depict the application route as publicly maintainable at that time. These maps were created for internal administrative purposes and were not intended to serve as definitive records for legal status or public rights. Furthermore, the original handover documentation for the relevant area was reviewed and does not indicate that the route was considered a publicly maintainable highway at the time of that survey in 1929. Accordingly, this documentation does not support the assertion that the route was regarded as a public highway during that period. The parish survey cards initially recorded the application route as a CRB, denoting a carriage road used mainly as a bridleway. However, this annotation is not legally recognised and does not in itself establish the status or nature of rights over the route. During the special review conducted under the provisions of the Countryside Act 1968, the route was formally reclassified as a public footpath. Objections to this reclassification were duly considered, concluding in a public inquiry. At that public inquiry, the planning inspector concluded that there was insufficient evidence to support the existence of higher rights. Notably, the inspector observed that the council have surfaced each end of the route periodically, with the cost shared between the local authority and owners of 2 adjacent farms. This agreement is not indicative of public vehicular rights. Following that inquiry, it was determined that the route known as Public Footpath 10 Onecote should remain recorded as a public footpath on the definitive map. This decision was upheld by the Secretary of State at that public inquiry, thereby confirming the route's status as a public footpath following its reclassification under the special review. Highway data relating to the application route includes a list on the Section 36 Highways Act list. Section 36 of the Highways Act 1980 sets out the legal framework for identifying highways that are maintainable at public expense. It provides that local authorities are required to maintain a list of streets, a public record of all highways within their area that are maintainable at public expense, and it should be kept up to date and made available for public inspection. The Section 36 list does not itself confer public rights of way, but relates to the maintenance responsibility of highways that are considered public. The document received from Highways includes annotations and is dated the 1st of September 1987, which is following the special review. These annotations suggest that, at that time, reference was made to the application of a Section 47 procedure under the Highways Act 1980, which allows for the removal of maintenance responsibility where a highway is deemed unnecessary. This annotation strongly indicates that the internal intention was to initiate such a procedure, and that marked section of the route was deemed unnecessary for public use. It is not disputed that the route is publicly maintainable to the extent that it is recorded as a public footpath on the definitive map and statement. The Section 36 list is an administrative document and did not undergo any external scrutiny or legal validation, and does not confer or confirm any higher rights beyond those recorded on the definitive map and statement. The annotations referencing the Section 47 procedure align with the view that part of the route was considered unnecessary for public use and should not be maintained as public expense. And again, this evidence does not support the existence of public hire rights over the full length of the application route. Although the Section 47 procedure was not fully implemented and internal correspondence took place regarding the route's status, this does not carry legal weight in establishing hire rights or maintenance obligations beyond those of a public footpath. What is drawn from this evidence is that the intention of the surveyor at that time when the internal annotations were made. The historical maps, including the Ordnance Survey and commercial maps from the 19th and early 20th centuries, show inconsistent depictions of the route. While some maps indicate the physical presence of the route, they do not assign any legal status or confirm public rights. The variation in the depiction further suggests inconsistency in use and status. Landowners along the route have consistently stated that the route has not been used as a through road for general traffic, and their comments on the report can be seen at Addendum 1. The applicant's further comments on the report have been considered and are also appended to the report at Addendum 2. The comments made and documentation supplied offer no additional evidence to the evidence already considered by officers when reaching the recommendation contained within the report. Without further evidence of higher rights, the internal council correspondence does not add sufficient probity to the application to infer higher rights along the line of the route on the balance of probabilities. Under the Natural Environment and Rural Communities Act 2006, motorised vehicle rights are extinguished unless specific exceptions apply. In this case, the route was already shown on both the definitive map and statement as a public footpath and within the Section 36 list prior to the commencement of the Act, and so therefore the exception does not apply and cannot be taken into consideration in this application. Therefore, even if vehicular rights had existed, they would now be extinguished due to the NERC Act. Turning to the legal test, under Section 53(3)(c)(2) of the 1981 Act, the panel must be satisfied that the definitive map and statement is incorrect and that the route ought to be shown as a highway of a different description. The burden of proof lies with the applicant. If the evidence is evenly balanced, the existing classification as a public footpath must prevail. In summary, there is insufficient conclusive legal evidence to support the existence of public rights higher than those currently recorded. In the absence of further substantive evidence demonstrating such rights, it cannot be concluded on the balance of probabilities that a byway open to all traffic or any route carrying higher rights subsists along the claim route marked A to B on the plan attached to Appendix B. Accordingly, officers recommend that the application should be rejected and that no order be made to upgrade the claimed route to a byway open to all traffic on the definitive map and statement of public rights of way. Thank you. Happy to take any questions.
Okay, thanks, Laura. Any questions? Yeah.
Does it state how long the road is or how long the pathway is? Because it seems quite a long one, actually. And does it join anything together? Is it like a shortcut between any villages or anything?
So I haven't got the details of how long the road is with me. I'd have to speak to our mapping team with regards to the length of the route. It does meet with two highways at either end, yes.
Any other questions, Neil?
Yeah, as I look at it, like you say, it's not used like for any other than the walkway. It's not used, and it might be used just as a shortcut, so that will increase the traffic along that pathway if there is any traffic that can get along there. So, yeah, my opinion is, you know, there's no evidence really that to say that it's anything but just a shortcut for a footpath through to the villages.
Okay, thank you. Shall we have a vote to approve the application?
To accept the recommendation.
Accept the recommendations, yeah.
I accept it should be rejected, yeah.
Yeah, I agree.
Yeah.
Unanimous.
Okay. That's conclusive. Thank you. Item 6 on the agenda. Wildlife and Countryside Act 1981. Application to add a public footpath between Quarry Bank Road and Staveley Place in the parish of Keele and Silverdale Parish. If I can pass it over to Stephanie. Thank you.
Good morning, Chair and members. Thank you. This report is based on an application made under Section 53 of the Wildlife and Countryside Act 1981 for a claimed route in the borough of Newcastle, commencing off Quarry Bank in Keele and ending at Staveley Place in Silverdale. The application was submitted in August 1998 by Keele Parish Council, and the route can be seen marked A to B at Appendix B to the report. The recommendation from your officers is to accept the application to make an order for a public footpath along the claimed route. The applicant's evidence included 14 user evidence forms completed between August 1995 and July 1996. To claim the route under statute, the Highways Act 1980 sets out the test which must be satisfied for a way to become a public highway through usage by the public. Section 31(1) states, where a way over any land other than a way of such a character that use of it by the public could not give rise at common law to any presumption of dedication, has been actually enjoyed by the public as of right and without interruption for a full period of 20 years, the way is deemed to have been dedicated as a highway, and unless there is sufficient evidence that there was no intention to dedicate it. Section 31(2) states the period of 20 years is to be calculated retrospectively from the date when the right of the public to use the way is brought into question, whether by notice or otherwise. The 20-year proved difficult to establish from the user evidence forms, and consequently the evidence from Landowner 1 was applied to provide the date at which the use was brought into question. Landowner 1 stated that there was a gate locked at Quarry Bank, new gate installed by County Council 1992 and locked by myself. In the absence of any other conclusive evidence, 1992 was therefore accepted to be the date of the challenge. Under the Section 31 test, 8 users did not meet the qualifying criteria. These included 2 users who did not use the route for the 20-year period and 3 users who had ceased using the route at the date that the route was brought into question. 3 further users were given permission to use the route. 6 users, therefore, were qualified to use the route. 3 used the route daily, 2 used the route once a week, and 1 used the route approximately once a fortnight. 6 landowners responded, and a letter of support for one of the landowners was also submitted. Their evidence forms were completed in 1998 at the time of the application, which was some 6 years after the use of the route was brought into question. Landowner 1 and Landowner 2 sold their respective land in 1993 and 1996. It appears that Landowner 1 was unaware that anyone had been using the route and that a gate had been installed by the County Council in 1992, which they locked. Landowner 2 stated that they did not believe that anyone was using the field as a throughway, although they did get the occasional trespasser, and that a gate which was locked in or around 1991 when Keele bypass was completed prevented use. They stated that there were also deterrent notices erected in about 1992 to 1993. Landowner 3 was clear that when they purchased the field in about 1993 from Landowner 1, the field was well secured and that it was they who had erected the deterrent notices. Landowner 5, who purchased land in 1996 from landowner 2, appears to have been unaware of any public use, but was concerned about privacy and antisocial behaviour should the application be successful. The statutory consultees were consulted, which included Newcastle Borough Council. Newcastle Borough Council, it may be noted, were also landowners. They were concerned that the claimed route passes over the municipal golf course which they managed. They did not provide any further evidence, although were concerned that they could not guarantee the safety of those using the footpath if the application was successful. No further evidence was received from either of the parish councils or the user groups. A report was drafted and circulated to all parties. 2 landowners responded to the report, details of which are included within the addendum. User 7, who became a landowner in 2004, contacted the council stating that they had not seen anyone using the route. They also had concerns regarding antisocial behaviour and littering should the application be successful. Officers responded that whilst they respected the issues raised by the landowners, the decision is based on the evidence as to whether officers believe the route exists in law or not. Newcastle Borough Council also responded to the report. They were under the belief that the route had already been considered. A small section of route had in fact been considered in a different Section 53 application. Officers advised Newcastle Borough Council that each route is considered on the totality of its evidence, and therefore this did not prevent a different decision on a section of route which had been considered in the past. Newcastle also stated that there was a Section 31(6) Highways Act 1980 landowner statement filed with the County Council, which included the golf course. This statement was filed in December 2020, and whilst this would defeat any applications in the future, it does not act retrospectively. Whilst it is clear that the evidence for the users is not particularly compelling, officers believe that there is sufficient evidence based upon the test of reasonable allegation under Section 53 3C1 of the 1981 Act. Officers therefore recommend that members accept the application based on the reasons contained within the report, and that an order should be made to add the route between points A to B on the plan attached at Appendix B to the definitive map and statement. I am happy to take any questions.
Thank you, Stephanie. Any other questions? Okay, I think we'll move forward. Shall we have a vote to approve the application?
To accept the recommendation.
Accept the recommendations, yeah. Yeah, that's unanimous. Thank you. Okay.
Thank you, Chair.
That concludes the meeting. Thank you.